So we're going to start by reading the case study that we're going to be going over today. So the case study is that Bob has attended the genitourinary clinic at his local trust hospital. Bob is seen by Dr. Gomez, who informs him that he is HIV positive. Dr. Gomez counsels Bob to contact his sexual partners to inform them of his status. Bob starts a course of treatment. For the last 18 months, Bob has been in a relationship with Sue. They are expecting a baby in 2 months' time. Before this relationship, Bob had a series of sexual partners. On a subsequent visit to the clinic, it becomes clear to Dr. Gomez that Bob has not told Sue of his HIV status. Dr. Gomez is aware of the impending arrival of their baby and tells Bob that steps should be taken to assess whether Sue is HIV positive and whether the baby is at risk so that necessary treatment may be started. Bob adamantly refuses to tell Sue and says that if she is told without his consent, he will stop his course of treatment. So the basis of the ethical conflict in this case is, what should Dr. Gomez do? Can or should he inform Sue or any previous sexual partners of his diagnosis? And the affected parties in this case are the doctor, the patient, the partners, the child, and society. So the values of the doctor are that he has ethical obligations to comprehensively contain communicable diseases acquired from birth, accidents, violence, or lifestyle choices of the patient. He also has to optimize health outcomes and reduce HIV incidence in society. The values of the patient are that they want to know that their personal health information is kept private and confidential, and they also have the right to decide for themselves who they should share their personal health information with. The values of the partners are that they have the right to know that if they have been infected or not, and they also have the right to seek treatment from a serious disease, which if untreated is life-threatening. The values of the child are that despite parents' refusal to consent to HIV testing, the child has the right to be tested at birth and begin treatment, and these rights are separate from those of its parents. And the values of society are the right to know the HIV statistics in the United States as well as globally. Some examples of these statistics include new evolving cases based on age, race, and gender, new treatment plans, if any, death totals, and the amount of people still living with the diagnosis. So now I guess we can go ahead and discuss the state laws that will set the groundwork for the ethical discussions in the state, or in the case study. So we can start with Catherine, who's going to discuss Alabama.
Yes, so in my research, I found that for the state of Alabama, informed consent is not required for HIV testing. Pre-test counseling is also not required. However, post-test counseling for HIV positive patients is required. There is no anonymous testing available in the state of Alabama, and partner notification is required. Now, having said that, backing up to the informed consent not being required, the physician can, at their own discretion, test any patient for HIV or AIDS based upon just what they've told in their visit at the doctor. So if he's got multiple sexual partners, or if he's an IV drug user, or she, however he presents himself, the doctor has their own discretion to order the HIV testing without notifying the patient. However, if that test comes back positive, then they have to backtrack and tell the patient, oh, by the way, I tested you for HIV and you tested positive. State of Alabama is a misdemeanor charge if I am HIV positive and I have sex with someone and they contract HIV. It's a misdemeanor. However, they do not have to contract the disease You can be charged with the crime, just knowing that you have the disease and you did not do anything to protect the other person. So you can still be charged with transmitting an STD is the actual charge in Alabama. So it's a Class B misdemeanor, punishable up to 3 months in jail, which is crazy because 3 months and somebody might be dying from HIV because of you. There's also fines, but only up to $500. Now, and they can do, both, whatever. There's probation. So some people may not get any of that. They may only get probation. Let's see. I know there's more good information. The pregnant, going back to pregnant women, they have an opt-out of testing. So, a lot of the OBGYNs here in the state of Alabama will encourage STD testing during pregnancy. However, the mom-to-be has an option of opting out of that testing. So in the case of this scenario that we're discussing with Bob and Sue, even if they asked Sue to be tested, if she did know that Bob was HIV positive and she was tested, she had the option of opting out of that testing. Also in the state of Alabama, because it is only a misdemeanor charge. Wait, that's not what I want to say. Back to if they have to partner notification required. I read several physicians here feel like that that is a state law, that partner notification is required. However, the federal law, HIPAA, which is the privacy confidentiality rule, they feel that trumps the state law in Alabama, in which case it's required to notify the partner. So Alabama physicians here would rather side with the feds than with the state. And, when the patient's only getting 3 months in jail for being HIV positive and, just have the intent, or not even have the intent to spread the disease, just in participating in any kind of activity where that could be possible, it's up to 3 months. And Alabama is only one of 16 states in which it's a misdemeanor. I think all the other states are felonies. I did a little cumulative cases in Alabama as of December 31st of 2016. Alabama had 20,351 cases of HIV and AIDS, with 435 of those being diagnosed in the year of 2016. And I'm skipping around, but I think that's all I got for Alabama at the moment.
Okay. So we will start with the state of Florida. Within the state of Florida, the patient's rights and also the pregnant woman's rights in the state of Florida overlap with the state laws and the federal laws, so they kind of agree with each other. So we're going to start with the patient's rights first when it comes to HIV testing. They can do either confidential HIV testing or anonymous. With confidential HIV testing, this is when the patient's protected health information is attached to the patient's HIV test and is then stored in the patient's medical record, shared only with the patient's physicians and the insurance companies for billing purposes. With this form of HIV testing, the physicians must have informed consent signed by the patient. This can be written or oral, and partner notification is not required. With anonymous HIV testing, this is when the patient's information is not tied to the HIV test. In fact, they get a unique number identification to get their test results. With this, the physicians must notify the patient that this form of HIV testing is open for use. Some physicians won't tell them. It is also the most private form of HIV testing allowed. It can be done in the patient's home, and it protects the patient from any risk of discrimination, and partner notification is not required. I found another law. It's called the MSHI Act, and this was actually the first law to come into effect because Florida had the highest rate of HIV back in the year, I believe it was like 1988. But however, the MSHI Act attempts to protect or prohibit HIV testing without knowledge or consent. It gives the patient special rights to manage and control their who receives their HIV test results. It requires that the healthcare providers obtain informed consent, and it also makes sure that the provider is required by law to report the name of the patient to the county health department if their HIV test comes back positive. The patient also has the choice to choose a site that tests anonymously, and their healthcare provider must provide this list, and a patient must be provided information concerning the extent of the confidentiality rights in terms of the test results that reside in the provider's medical record. When it comes to, under this law, when it comes to this, physicians have consequences when they're testing without informed consent. In this case, the healthcare professionals performing HIV testing without informed consent are subject to actions of their licensing board, including fines, suspension, or revoking of license. The provider may also be sued in civil court by the subject for negligence, battery, and invasion of privacy. When it comes to confidentiality, the HIV test results are considered to be super confidential. Only the fact that the HIV test was performed and the results are, no matter if they're positive or negative, they are supposed to be protected regardless. Even if there was a lab report and it's mentioned, the lab report goes inside the medical record and it has to remain protected. Any consequences of breaking the confidentiality, it will make it a third-degree felony, and the physician is punishable up to 5 years in prison. And that goes for anyone who releases or distributes information that identifies an individual with HIV to anyone other than a physician or nurse employed by the Department of Health or law enforcement agency. Now we're going to talk about the pregnant woman's rights in Florida. They have two options, the opt-in and opt-out, just like the state of Alabama. If she opts in to take the HIV test during pregnancy, then she gets educated about the HIV testing process. However, before the doctor performs the HIV testing, he must have informed consent. Now, if the patient decides to opt out, then, of course, the physician has to ask her multiple times throughout the pregnancy if she wants to be tested or treated. If she still declines, then the physician has to put a note in her chart every time that she declines, stating that she declined taking the HIV testing. And then at that point, the physician has to test the baby when the baby comes out to see if the baby's HIV positive or negative. If the baby is HIV positive, he is ethically responsible to report this incident to the state, and he has until the baby turns into 18 months. So it's from newborn to 18 months to report this diagnosis to the state, so that way they can keep surveillance over the baby. And that sums it up for Florida.
Okay. I will be discussing New York State. Do you want me to discuss Michigan? Okay. I will be discussing the state laws for Michigan. In Michigan, testing for HIV requires informed consent, except in the situation where the patient is unable to give informed consent and an authorized representative is not present on their behalf. If the test is performed for a double-blinded research study, or if it is performed after a health professional, a police officer, firefighter, EMT, or licensed paramedic acquires a percutaneous mucous membrane or an open wound exposure to blood or other bodily fluids of the patient in the facility or while en route to the healthcare facility,
The providers must report HIV diagnostic test results to the state or local health department within 7 days of receiving the positive test result. Providers are required to complete the adult or pediatric HIV/AIDS confidential case report, which includes the patient's name, date of birth, race, sex, address, and telephone number of the patient. A patient who undergoes a test for HIV or an antibody to HIV in a physician's private practice office or in a physician's office employed by or under contract to a health maintenance organization may request that the provider submit the case report without their name, address, or telephone number. If this request is made, then the provider shall complete the case report form and submit the specimen to the lab without this identifying information. Many states have partner notification laws, meaning that if one tests positive for HIV, they or the healthcare provider may be legally obligated to tell any partners. In Michigan, for example, they've enacted a statute requiring physicians to notify the contacts of an HIV positive patient if this disclosure is necessary to prevent further transmission of HIV. In the event the provider is statutorily authorized to notify the partner, they should comply strictly with the laws. If the provider does not inform the partner, they can be held liable on the basis that they were not doing good enough to prevent harm done onto others while such law exists. Providers have been sued for failing to warn a partner about possible HIV infection. Depending on the state, there can be criminal charges for a failure to notify a partner of the HIV status. In Michigan, it is a felony not to notify a partner of an HIV positive status prior to engaging in sexual penetration. Michigan also requires physicians to test pregnant women for HIV or an antibody to HIV unless the woman refuses consent or the physician determines the test is medically inadvisable. In the event the physician is required by Michigan law to record the client's test results and date of testing in her medical record, if the patient does refuse testing, this must also be documented in the patient's chart. And that sums it up for Michigan.
Okay, for the state of New York. New York State has long been the center of the AIDS epidemic in the United States. Approximately 18% of the nation's cumulative AIDS diagnosis has occurred in New York State. And New York ranks second only to Washington, D.C. in terms of its AIDS diagnosis rate. The number of new HIV diagnoses has fallen steadily over the past 10 years. Despite this promising trend, New York State still accounts for approximately 10% of the nation's new HIV diagnoses. Of particular note, men that have sex with men and persons of color remain disproportionately affected by HIV/AIDS in New York State. Substantial work remains to ensure that favorable trends in the HIV epidemic persist. AIDS case surveillance, however, is no longer able to monitor the current status of the overall HIV epidemic. Because it takes several years for persons to progress from HIV to AIDS, AIDS surveillance data reflect disease transmission patterns in the distant past rather than recent experience. The event of highly active antiretroviral therapy, HAART, has significantly lowered progression to AIDS in many persons with HIV, further reducing the value of AIDS data in the tracking the HIV epidemic and obtaining information to guide prevention and care programming. New York State passed its HIV reporting and partner notification, HIV RPN law, to address the deficiency of AIDS surveillance as a mechanism to track the HIV epidemic. Effective January 1st, 2000, the HIV RPN law requires the reporting of persons with HIV infection, HIV-related illness, and AIDS by physicians, other healthcare providers, and by laboratories performing diagnostic tests. The law also requires reporting known contacts of persons with HIV or AIDS and contact notification when merited to protect the public's health. In addition, the legislation requires that a domestic or intimate partner violence IPV screen be applied to each identified partner, with notification being deferred in cases where a risk of violence exists. Finally, the law retains an anonymous HIV counseling and testing option in New York State. In New York, when considering disclosure laws pursuant to a release of a patient information without consent, no right is held more sacred. or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others, unless by clear and unquestionable authority of law to make decisions on releasing health information in the form of a consent. In New York, the Article 27-F establishes the basic rule that no individual may be given an HIV test unless that individual first is told about and given the opportunity to choose either anonymous or confidential HIV testing, plus receive pre-test information the law requires to be given to enable the person tested to make an informed decision about whether or not to be tested. As of April 1st, 2014, written consent is no longer needed, just a verbal agreement that must be documented in the chart or electronic record appropriately. The healthcare provider that orders the HIV test must ensure that this information is given to the patient before the test can be performed. Once the test has been administered and the results given back to the patient, all written disclosures of confidential HIV information must be accompanied by a statement prohibiting redisclosure to protect the individual's right to privacy. As a HIM professional trying to reason this ethical decision-making process by understanding the basis of the HIV disclosure to partner rights by physicians from the legal and ethical approach can help provide the information for developing the best choice for this outcome. When the physician is choosing to disclose or not disclose the patient information to the girlfriend, there are two ways he should decide in the state of New York, the legal side or ethical side. The physician has the legal choice to communicate or not communicate the confidential HIV results to the partners. If he chooses to keep the HIV information confidential, he is honoring the legal confidentiality agreement he made not to disclose personal health information without the proper release and will not be held liable for not disclosing the information. The physician can, when he reports the mandated new diagnosis report for the newfound HIV case to the Health Department of New York, he can use the physician's discretionary reporting of the contacts at that time to disclose the contacts without obtaining an HIV-specific release form. He can report the names of the contacts as well as the information about the HIV-infected patient involved to public health authorities for the purpose of initiating notification efforts. If the physician believes that the notification is medically appropriate and there is significant risk of infection to the contact, and the physician or its agent has given the protected individual the counseling and information about the notification and the required domestic violence screening has been applied, the names can be given to the health department and they will be responsible for contacting anyone regarding previous partner HIV status. As of February 1997, once a baby is born in the state of New York, all babies are tested at birth for the presence of HIV antibodies. This will also provide information about the mother's HIV status as well. That's for the state of New York.
Okay, and I will be discussing the state of California. And the California Health and Safety Code states that any person who exposes another to HIV by engaging in unprotected sexual activity, when the infected person knows at the time of unprotected sex that he or she is infected with HIV, and they have not disclosed his or her HIV positive status, and acts with the specific intent to infect the other person with HIV, is guilty of a felony. So in California, the law clarifies that a person's knowledge of his or her HIV positive status without additional evidence is not sufficient to prove specific intent. So if you're having protected sex, you're not guilty of a felony in California. You have to be trying to give the other person HIV. And also California state law requires that providers or clinics forward all HIV positive patient tests to a local health officer who then reports the case to the California Department of Public Health. And these records can never be released, even in a criminal trial. And if a person does willfully disclose a patient's confidential HIV testing information to a third party, they can be charged with a misdemeanor. Now, as far as pregnant patients go, the state of California does require a licensed physician or the surgeon or any other person engaged in the prenatal care of a patient woman to inform the pregnant person that they do want to perform an HIV test and that this test is routine in nature and its purpose, risk, and benefits of the test. They also need to disclose the risk of perinatal transmission of HIV and that approved treatments are known to decrease the risk of perinatal transmission of HIV, and the patient also has the right to decline the test. So if the person does decide to take the test, after the test results are received, the physician and surgeon or other person engaged in the prenatal care of the pregnant woman or attending to the woman at the time of labor, delivery, or postpartum care has to ensure that the woman receives information and counseling as appropriate to explain the woman's results and the implication to the mother and the infant's health. And this includes follow-up testing and care that is required. If the woman does test positive to HIV, she shall be referred to a provider group, or institution that specializes in prenatal and postpartum care for her and her baby. So that kind of, as we went through 5 different states, we kind of heard the difference in state laws. So now that we know that, we can go back to the case study and use that as well as the ethical reasoning to determine whether the harms of non-disclosure or the harms of disclosure are more significant. So using both of those, what do we think that the risk that Sue might be HIV positive, is that worth disclosing Bob's HIV status alone?
Okay, for me being on the against side, I understand that yes, being HIV positive can affect Sue and the unborn child's health, but what about Bob's right to autonomy? His legal and ethical rights are to make the best medical decisions for himself. He has the right to autonomy, and with this right, he does not have to tell his pregnant girlfriend Sue about his HIV positive status. If he does not want to, then there is the patient and physician confidentiality. When Bob goes to see Dr. Gomez, his HIV positive test results should not be shared with anyone but the Department of Health or law enforcement agency. And if Dr. Gomez breaks the confidentiality between him and Bob, it is a 3rd-degree felony, and he can be punishable up to 5 years in prison. And this is just based off of Florida law.
Well, I'm against the physician disclosing to Sue about Bob's HIV status as well. And, I'm going off of Alabama law on this. First of all, according to Alabama law, the physician doesn't have to notify Sue. The physician can test Sue, and it's a 50-50 shot, and hoping to get a negative test result. However, should Sue be positive, then the physician has a obligation and a requirement by law to tell Sue, I tested you, and this is you have a positive test result, but let's just go hypothetical. We don't really know the whole story to this case study. So what if the physician tests Sue and Sue's positive, but come to find out Sue gave it to Bob? For me, it's going on Alabama law. The physician can test Sue. Sue doesn't ever have to know. And ethically, I think, the physician needs to look at it from all aspects. Bob's, like Didrika said, Bob's privacy and confidentiality, a right to autonomy, But, you know, the physician also, he just needs to have the practical wisdom to know when and how to put the knowledge, his expertise and skills into action. You know, I mean, there's a way he could do it that supports the part of probably Bob that wants to do the right thing and tell Sue. But at the same time, it's that finding the balance, and having the self-awareness to recognize that, I'm sure the physician has a bias, he's biased in this, conflict, and it's not easy in Alabama though. He has the law on his side, and he can test Sue and at least, get that monkey off his back by doing that. That's my take on it.
Okay. And I am for the provider informing Sue of this information. If you look at it, if the provider will only base their decision on the need for respecting Bob's autonomy, then he might not disclose the personal information without consent. But in this situation, more than Bob is just affected, we have to look at the autonomy of Sue and her unborn child. Not informing Sue sets limits over which she has no control on her ability to make informed choices for her, but also tying in the choices of her unborn child. There are steps that she could take currently to prevent the HIV being transmitted to her, and possibly even prevent the transmission to her baby. And if you're looking back on Michigan state law does require physicians to notify the contact of an HIV positive person if this disclosure is necessary to prevent further transmission of HIV. In this situation, Bob has yet to disclose his status to Sue, and so he is currently increasing Sue's odds of contracting HIV. So by following that law, the provider would be in line with saying to Sue that she's at risk for HIV, is how I feel.
All right, on my end, I am also for telling Sue. I found that the doctor has the ethical obligation to support, just by going from principle number 9 and number 7 from the American Medical Association principles of medical ethics. It supports access to medical care for all people and shall recognize the responsibility to participate in activities contributing to the improvement of the community and the betterment of public health. By refraining and choosing not to disclose directly to the partner the HIV status, he is denying the opportunity for medical care to be provided to the unborn fetus and its mother, and he has an obligation to respect his civil duty and by good faith report the HIV infection of the partner to the mother of the unborn child to allow her the opportunity to be medically treated and tested for HIV virus. And the state of New York supports his decision by the HIV RPN law that requires reporting of persons with their partner, disclosing to partners their HIV infection.
Okay, and for California as well, it's interesting listening to everybody how it seems as though the ethical dilemmas seem to contradict a lot of the laws. So what you might feel is correct is actually not legal, and that's the same in California. So California state laws actually says that the healthcare provider must just report to the California Department of Health, and if they do disclose the HIV status to any third party, that the provider would be guilty of a misdemeanor. So I think that as we go along, we might find that, while you might think that, of course, if a provider knows that someone is HIV ethically, you would think that that's the right thing to do, but legally it's not. So we'll move on to the next question and see if we all have come up with the same conclusion. So if Sue is HIV positive and is not aware of the risk and the consequences, that she will not take the steps to minimize the risk of infection to the baby, such as obtaining treatment during pregnancy, the baby being born by C-section, not breastfeeding the baby, and taking prophylactic treatment. So how do we feel about that?
I just feel like at the end of the day, being pregnant she still has the rights to either opt in or opt out to get the HIV testing. So even if she did find out, it's still her right to get treatment for the baby. She doesn't necessarily have to. And then again, she still is a patient and she still has her rights to privacy, confidentiality, and things of that nature. I mean, that's how I feel.
For me, again, I'm against it. So, I actually when I was pregnant with my first child, I lived in Jacksonville, Florida, and the physician asked me, it was, I don't know, 4 months pregnant or whatever it was, and asked me for the STD testing and HIV, and, I declined it. And it wasn't that I declined it because I didn't want to know. I mean, I'm a nurse. I'd had a needle stick. I had already been through all that, so I knew I didn't have it. But I declined it because it wasn't going to change anything. I wasn't going to terminate my pregnancy. And that's all I kept thinking. The physician never sat me down and said, hey, this is completely treatable. We can prevent transmission to your, daughter should you be positive. I said no, I opted out and went about my merry way. So, I don't know. I think, again, it's up to for the state of Alabama, the physician can sue, regardless. So, I'm still against it.
Yeah, and I'm for it. And there's studies out there that have shown that with the appropriate medications and interventions, the HIV transmission from the mother to the baby can be as low as 1% to 2%. But in that situation, she needs to be informed first. For Sue, according to the law of Michigan, she can be tested for HIV during her pregnancy, but she does have the option to opt out. So there could be another way of her finding out without Bob actually telling her. But finding out sooner versus later can make the odds for treatment more in her favor. So ideally, if the provider were to tell her as soon as possible, granted in this case scenario, I believe she's only 2 months from delivery, but even still, knowing prior to delivery is very important because just doing a C-section versus a vaginal delivery can decrease the chances. So overall, I still feel that the provider needs to inform her just for the sake of the baby because in this case scenario, someone needs to look out for that child. I mean, that child's not making decisions on their own, so they need to look out for the own well-being of the baby.
And the baby would also need to start the regimen if she was HIV positive as soon as it was born, or if she chose to breastfeed or not breastfeed. The ARV drug she would need to take every day. If the baby turned out negative, she has the right. I mean, if she wanted to breastfeed, she needs to know that there is a possibility that she could transfer the HIV through breastfeeding or through the birth, as it was mentioned. So I'm still for telling Sue, having the provider tell the Sue if he chooses not
to. Okay, and also another thing to consider is based on federal law, that the fetus doesn't have legal rights, but the rights crystallize at birth. So ethically, we think that, of course, the mother has the right to know because you want to protect the fetus. But I think in most of the state laws that we've talked about, once the baby's born, then doctors have the right to test the baby and they have the right to receive treatment, but that does not materialize until birth. So that's also another, question to consider. But, so we can go ahead and move on to the next question. So if Sue did later find out that there was a risk to her and that she was not informed, she might lose trust in her doctors or in the healthcare system. So would that be enough of a reason to disclose Bob's status?
Well, in the state of Florida, regardless of the fact, the physician still cannot tell the patient's status of being HIV positive. So in this aspect, I'm going to look at it more on the ethical side, because it still was still made aware of Bob's HIV positive status. This still brings his right to privacy. His legal right to privacy gives him the choice to control who can and cannot have access to his medical record. Privacy gives him the right to be let alone, and it also, if he doesn't want to be educated about the HIV process or it affecting Sue and the newborn baby, then he doesn't have to listen if he doesn't want to. And that's just being on the against side.
You know, for me, against it, who's the patient of the physician? It's Bob's the patient of the physician, right? Not Sue. So I think the physician has a, physician-patient obligation to maintain his privacy and confidentiality. Sure, ethically, in his gut and in his heart, he wants Sue to know. But his obligation is not to Sue. The obligation is to Bob.
Okay. On the side for it, if you're looking, the American Medical Association's policy on HIV testing, that states that physicians must honor their obligation to promote the public's health by working to prevent HIV-positive individuals from infecting third parties within the constraints of the law. So if an HIV-positive individual poses a significant threat of infecting an identifiable third party, the physician should notify the public health authorities if required by law. Attempt to persuade the infected patient to cease endangering the third party, and if permitted by state law, notify that endangered third party themselves without revealing the identity of the source person. So if a provider does not stay true to this policy, then if Sue were to find out later that she was at risk for her contracting HIV, she can lose trust in her provider and the healthcare system as a whole. This ultimately will actually have an effect on the patient-provider relationship that she has. So in this situation, the provider does have the law on his side, so he can go ahead and feel in good conscience that he can break that confidentiality, patient confidentiality he has with Bob by reporting to Sue of the HIV positive status.
And once the baby's born, it's going to be tested for HIV. If it comes up positive at that point, there's going to be many questions ethically that he's going to have to answer if she went back to him and wanted to know why she wasn't informed.
Right, and that makes sense. And so that brings up actually the next question. So if she found out, retroactively that she was exposed to HIV and she wasn't told, do Bob's former sexual partners, as well as anyone, I guess, that he could potentially infect in the future, do they have a right to be contacted or informed by the physician?
Based off the case study, we really don't know if they were faithful to each other. We don't even know if they were in long-lasting relationships before then. We don't know if Bob stepped around. We don't know if Sue stepped around. We don't know if they cheated on each other, So ethically, I don't think it would change anything. And that's all I have to say.
I want to echo kind of what Dedrika said. For me, we don't know either of their past. This could be IV drug use from 10 years prior or whatever that maybe, Bob thought was buried or Sue thought was buried. We don't know. I don't know. I just think the physician's obligation is to his own patient. So I don't know. That's just how I feel. Keep talking. Y'all might change my mind though.
Well, utilitarianism, it's a theory that morally right action is that which produces the greatest good. So if the provider discloses Bob's HIV status to Sue and previous partners without his consent, and it decreases the odds of further HIV spreading and increases the likelihood for those to seek treatment early, then disclosing his status cannot be wrong. The provider is doing their due diligence and promoting good by trying to decrease the risk for harm in Sue and her baby and for Bob's previous partners, and down the line for his possible partners to come.
Okay, so if we've gone through all of the harms of non-disclosure, we can go ahead and talk about the harms that could come from Dr. Gomez disclosing the HIV positive status. So the first would be that if he informs Sue or others without Bob's consent, that as a consequence, Bob might lose trust in Dr. Gomez or the medical profession in general. So would that be enough of a reason to not disclose his status?
Just listening to all the other states and ethically and morally, regardless of him losing trust of Dr. Gomez, I think the baby is more at stake at this point, and we have to do what's ethically right for the baby, regardless of how I feel.
So just to add to that, the fact that he says that he'll end his course of treatment, which could result in a relapse or, health problems, including death, would that make a difference, as well as him losing trust in the health profession?
Say, well, this is what I'm going to do if you do this. But at the same time, it's like, okay, well, he does have all his rights, from privacy to confidentiality to autonomy. But what about Sue? What about the baby who's not even here, who can't even speak for itself? So I think it just depends on Dr. Gomez and how he feels at the moment. What should he do morally for the protection of the baby?
And he could just involve the health department and get the health department to contact the partners. And he could just relay the information that way, and he would not break the confidentiality agreement that he has with Bob. That would be a top
tier. Right. And I think that's a good point. And additionally, what it doesn't talk about in the case study is if he just went to Sue and offered an HIV test, which I think most of our state laws actually require, she might accept, and he would not have to necessarily disclose Bob's HIV status. You could let her infer upon, if she's been in an 18-month relationship and all of a sudden she becomes HIV positive, she's probably going to realize that Bob has it, and Dr. Gomez doesn't have to specifically tell her and, break confidentiality, but by giving her the option to take the HIV test, she might accept, and then we wouldn't have to worry about the rest of it. So that's also a possibility.
Post-counseling is huge. I think I know of the states that we've mentioned, it's a requirement. So, as long as both patients get the appropriate counseling, I know the state of Alabama, has, indigent programs where the medication, social services, any type of treatment to help the patient, get through the process. All of those are available. And I think that if Dr. Gomez goes about it the right way, truthfully, he could probably make both parties, somewhat happy. He can keep the trust of Bob yet gain trust of Sue. And, I'm kind of with Edrika. The baby doesn't have rights at the moment. So I can be against it all day long, but I think at the end of the day, the baby is what's most important for me. In which case, if it were testing the baby, hands down, I would definitely say yes. Breach whatever law you want to, confidentiality, whatever, if it means the treatment of the baby, appropriately and timely.
And can I just add, we never know that Sue may say,
Okay.
in confidentiality to Dr. Gomez, I already know the situation because it was me. You never know how it's gonna, play out.
Right. That's a good point. Yeah. It doesn't state in the case study if she knows she has it. So, okay. So I guess that would bring us I guess we've already sort of got here, but to our conclusion, putting together, the ethics and the laws that we discussed, what do we feel at this point would be the best course for Dr. Gomez to take? Just, kind of in a blanketed statement. Should he tell? Should he not tell? I'll say personally, I think that the laws in Alabama were probably the most fair to both parties, just because they could test Sue without her knowledge, and they only need to tell her if she's positive. So, that might not prevent everything in the future, but, to get rid of for better words, the elephant in the room right now, they could find out whether or not she's positive without breaking confidentiality. And if she is, then they could start, the course of treatment.
And I agree with that opinion as well. And then the other thing would be, too, after testing her, if she doesn't come back positive, educating Bob on the importance of things he can do to prevent the future spread of HIV, and encourage him to inform Sue or any other partners he may have, and just let him know the situation at hand. Someone else were to be pregnant, what could happen if that partner were to contract HIV. But I think education would be another key point here in this situation, and hopefully by showing him the information and the statistics, that could allow him to change his mind in the future and let Sue or any partners know, because he's putting other people's lives at risk at that point.
Yeah, and education I think is huge. HIV and AIDS is not the same disease per se that it was in the 1990s. What I was reading was if we can educate globally that it is a virus, just like RSV is a virus, just like the flu is a virus. It is treatable. It is not curable, however, but it is not terminal today like it was in the early 90s. So I think education is huge. And I think that's what we need to get at in just globally, United States, all over. Just stress the importance of protecting yourself and others, and safety of others, safety of yourself. It's treatable today.
Right. I have to say that I have to piggyback off for all you guys. As far as in education and treatment, like you just said, Katie, that treatment is not the same as it was in the past to now it's treatable. You might have to take a pill or two a day, but at the same time, it's one of those things where the more we educate, the more we can do, not just as a person or not just as Dr. Gomez by himself, but as other physicians as well. And so as the patient, they can educate as well. If a person has it, they can educate and say, well, hey, I had this and this is the medication regimen that I'm on. It may not be the same regimen for you, but I'm a living witness, our testimony that I'm still living with this disease. It's not curable, like you guys said, but at the same time, I'm still living. But yeah, I agree with all of you guys that at this point he should tell because of the baby and to prevent future incidents from occurring.
Okay, does anybody else have anything else to add?
I think y'all summed it up great.
Okay, sounds good. I don't know if if you want to stop the recording.